Welcome, everybody. This is our second presentation by the Estate and Tax Planning Council of Eastern Connecticut. It is part of our Demystifying Estate Planning and Probate Series, and we are glad that you are choosing to view our panel discussion. The Estate Tax and Planning Council of Eastern Connecticut is a group of local professionals. Our mission is to educate members and inform the community with outreach programs, just like this one. In this session, we will be talking about powers of attorney, medical advance directives, and conservatorships. And our panelists are attorney Neal Bobruff and attorney Richard Dixon. Attorney Bobruff received his law degree from the University of Connecticut in 1983. He also has a master's degree in taxation from Boston University Law School. He is licensed to practice law in both Connecticut and Florida. His offices are located in Old Mystic Village, and he practices primarily in the areas of estate planning, probate, wills, trusts, real estate, and elder law. He is a member of the Executive Committee of Estates and Probate section of the Connecticut Bar Association and a member of its sections on elder law and real estate. He is also a member of the National Academy of Elder Law Attorneys. Neal is a past president of the Estate and Tax Planning Council of Eastern Connecticut, the Mystic and Noank Library, and the Lawrence and Memorial Hospital Benefactor Society. He has served on the board of directors of several other community organizations, including the Community Foundation of Eastern Connecticut. Attorney Richard Dixon also has an office located in Mystic, Connecticut. He's been practicing law here in New London County since 1984. His practice concentrates in probate, trust, estates, elder law, small business formation, real estate matters, including residential purchase and sale transactions, title issues, real property, land use, and environmental matters. He is admitted to practice before Connecticut state courts and the federal district court. He has been a member of the National Academy of Elder Law Attorneys, the Connecticut Bar Association, the Connecticut Bar Environmental Committee, the New London County Bar Association, the American Bar Association, and the American Trial Lawyers Association, and is a member of the Elder Law and Real Property sections of the Connecticut Bar Association. He is also a member and past board member of the Estate and Tax Planning Council of Eastern Connecticut. He is joined in his office by Anne Marie Foster, RRT GCM. Ms. Foster is a healthcare professional and geriatric care manager, assisting elderly and disabled clients to maintain their independence and providing guidance in navigating the myriad of public agencies and programs to assure that quality of life is maintained. Both Neal and Richard have websites, and you will see that information at the conclusion of this presentation. Thank you. So I'm going to introduce Attorney Bobruff, who is going to discuss powers of attorney and then medical advance directives.
Thank you, Ellin, and thank you to the Estate and Tax Planning Council for giving us this opportunity to explain to the public these different areas of estate planning law. My topics are going to be powers of attorney and advanced medical directives, which is going to lead into Attorney Dixon's presentation on conservatorships, which is related to my two areas. So first I'll talk about powers of attorney. And you may ask, why do attorneys always, estate planning attorneys always recommend powers of attorney? Well, if you think about all the things that you do in daily life having to do with your finances that you never really consider, there's really quite a lot. From you get an electric bill and you pay the bill, you pay your landlord or the mortgage company, you talk to your investment person about how you want your money invested, whether you want to buy this stock or another stock or a bond, or just whether you want to buy a CD. There are just an enormous amount of everyday financial decisions that you make that you are just so routine you don't ever think about. But attorneys are worried about what happens if you become disabled. And who's going to take over those responsibilities for you, who's going to pay your bills, invest your money, safeguard it, make sure your wishes are carried out. And the law has come up with a few different ways of addressing those problems. And the power of attorney is something that we strongly consider that people consider doing in consultation with an advisor, such as an estate planning attorney. So with the power of attorney, it's a written document where you are appointing someone else to make those, giving them the authority to make your financial decisions for you and manage your financial assets. And one of the advantages of doing this is you get to choose who your agent's going to be, and you get to set the terms of the authority that you're giving that person. And what is really driving all of this is that for some people, if you didn't have any financial agent appointed under a power of attorney, the only other way that your assets are going to be properly managed and looked after is for someone to go to the probate court and become or apply for a conservatorship, which Attorney Dixon is going to go into in great depth. So I'm not going to go over that now, but that's really the only alternative to make sure your bills get paid and your property gets properly managed. It's either the power of attorney or a conservatorship. Now you may say, well, gee, I have joint ownership with my spouse, so wouldn't that be enough? And the answer is no, not always, and there are problems. So, for instance, if you were in such a state of being disabled that your spouse decides that the two of you need to move to an assisted living facility, your spouse can't sell your property if you're on the deed just by themselves. So the power of attorney would step in and allow them to do that. The other problem can be with joint ownership, such as a bank account. Well, yes, your spouse might be able to pay your bills out of the joint bank account. But what happens if your spouse passes away? Then the power of attorney would allow you to name a successor agent to pay your bills and manage things. Plus, using a power of attorney is something that's important to make sure your estate plan is carried out. And what I mean by that is, and this is unfortunately a somewhat common situation, a parent has a will and they have two kids, and they name each kid to receive everything equally upon the death of the parent. And one kid's out on the West Coast and the other kid's local here in Connecticut. So they say, well, gee, I'm getting a little older, I'm having trouble writing my bills, so I'm just going to add my local child to my bank account. Well, what happens when you die is that the will no longer affects that joint bank account. It's not part of the probate estate to be split equally between the two kids, because the local child is already the owner of the bank account because their name was put on it. They inherit everything in that bank account, and it's up to them to be a good sibling and share and carry out their parents' intent, or for the child that was left out to bring an expensive lawsuit and try to sue the local child for half of the bank account. So it's just much better if the local child were put on the bank account as a power of attorney, where they won't inherit it, but they will be in a fiduciary position where they are supposed to pay the bills and manage the property of the principal who is authoring the attorney. Now, what is needed for a power of attorney is it just has to be in writing and executed with the same formalities that we execute a deed in Connecticut. And what that basically means is you need two witnesses and a notary or an attorney to take an oath and make sure that it's your free act and deed that you're signing. And once you sign a power of attorney, as long as you're alive and you still have capacity, you can amend or revoke the power of attorney at any time. There are lots of different types of powers of attorney. A frequent request I get in my office is people wanting a durable power of attorney. And what we mean by a durable power of attorney is that it is going to be good in case you do become disabled, which is, as I've tried to describe, pretty much the 99% of the reason we do powers of attorney is in case you become disabled. But that has to do with English common law, where powers of attorney would be actually revoked if you became disabled. But almost all powers of attorney should be durable powers of attorney to plan for your potential disability. The only reason other kind of power of attorney that might not be a durable power of attorney is if you it was more of a transactional. So say your spouse, you were selling your real estate and your spouse was going out of town and you had to have the closing on a particular date. When they weren't available, they could sign a power of attorney just for that real estate closing, and that would be a transactional power of attorney. There's also two different types of powers of attorney, and that has to do with when they go into effect. There are springing powers of attorney, which will spring into effect upon some naming of an occurrence. So for instance, you could say, this power of attorney is good on December 31st of 2040, or upon my 80th birthday, or upon a letter from my doctor saying that I am not capable of understanding medical decisions anymore. And that's something that Connecticut law allows, but it's important to know that not every state allows that. For instance, Florida has a prohibition against what I just referred to as these springing powers of attorney. They want the other type of power of attorney that is effective immediately upon your signing it. Now, again, powers of attorney are always revocable. So if you give a power of attorney that's effective immediately and you change your mind, you can always revoke the power of attorney. So it's not irrevocable once you sign it. It's very much changeable and revocable or amendable. When you talk with an attorney about a power of attorney, they're going to probably have their own preferences, but talk to you about the form of the power of attorney. Because in Connecticut, we have two different statutory forms, a short form and a long form. And depending on your situation, one may be more appropriate than another, depending on the level of your, the type of assets that you have and what you're trying to accomplish. Or a power of attorney can be very manuscripted, because you can say, well, gee, I want to give my agent this power, but not that power to manage my affairs. And so it's very helpful to give this a very thoughtful analysis of what powers you want to give to your agent, which is one of the reasons we tend to think it's not a great idea to go to a stationery store and just buy one off of the shelf that's supposed to apply to every individual who is shopping that day. But it's really good to give these make these decisions in a thoughtful, analytical way. When you name your agent to be your power of attorney, there is what we call a fiduciary relationship established. That means if you name your child your agent, they have a fiduciary responsibility to act in your best interest, not theirs. And that's a very important concept to understand, and for the agent particularly to understand what the responsibilities are. Because there are some legal responsibilities I'm going to talk about that happen when you are the agent. But there are some circumstances where principal might want to break that fiduciary responsibility, which would normally be in terms of estate planning, whether you want to give gifting powers, which could be for a number of different reasons, tax reasons and other reasons. But that would actually break the fiduciary responsibility to the extent that you allow gifting powers. So that's something else that sometimes can be accomplished in a power of attorney. And again, that's something you'd want to hear about all the pros and cons of whether you wanted to give an individual power or not. But in most cases, we don't give gifting powers. It is a fiduciary relationship. And there are definitely responsibilities under the law for the agent to not only invest your money and protect your property in your best interest, but also to keep detailed records. And that is important because if someone suspects that you are, if an agent is not acting properly, they can go to the probate court and request and demand an accounting of what the agent has been doing with your money. So that is just one of the protections that are in the law when you do a power of attorney, designed to really protect vulnerable people from abuse. And there is a potential for abuse. And that is why one of the many discussions that we'll ask clients to think about is, do you really have a trusted person to be your agent? Because the neighbor who moved in 3 weeks ago, who decides that they would really like to help you out and suggests they become an agent, they may or may not be a good person. And you might be better off with probate court supervision, as Attorney Dixon's going to talk about with a conservatorship, if you're worried about decision-making when you're disabled or incapacitated. So really that choice of a trusted person is a very, very important decision. The other thing that we like to have clients think about when they're contemplating doing a power of attorney is what happens if the person you name as the agent becomes incapacitated or dies or moves away and isn't interested in doing the job anymore. Well, we like to name successors. If you have more than one trusted person, you can name person A to be the successor, or person B to be their successor if person A can't do it for whatever reason. And there are other things that we can put into powers of attorney. One of the new things in the law is dealing with digital assets. If you have your Facebook account and so forth, and you want it managed while you're disabled, we can put those type of powers in there. So it's really a lot of questions that your attorney is going to ask you for you to think about and make some decisions. But it's all designed to figure out a way to safely manage your money and protect it in your financial assets and your other property in the event that you become incapacitated for either medical reasons or other reasons. So that is really what I want to tell you about financial powers, durable powers of attorney. I will see if Attorney Dixon or Attorney Grenger, do you have anything you'd like to add or ask me about?
I don't. I think it was very important that we talk about trusted relationships. And so I think you covered that thoroughly.
I have a couple of comments that I think I can bring into when we get to my conservator part about the way that the two things work together. So I will expect you to pop in on that maybe at the end, and we can discuss the interplay of the two types of ways of assisting people when that they do have limited capacity or otherwise want somebody else to manage their affairs.
Excellent. I think I know what you're getting at. That's a good point that we'll discuss in your section. Thank you. So then I'm going to move on to advanced medical directives, which is another thing that I think, I don't know another attorney who doesn't have a client who comes in for simple wills who doesn't also talk to them about financial powers of attorney and advanced medical directives. And so advanced medical directives, which is a pretty broad term, covers a number of things. And in the documents we draft, you can keep in mind that you can do some or all of these parts that I'm going to describe, because just like the power of attorney, you are in charge of what your document says and the decisions you want to make and what you want to have your document say. So the first part, in all of these documents really got much more popular because of the development of law and a Supreme Court decision that basically reiterated that you not only have the right to make your own medical decisions and control your person, but you also have a right to decide whether you want to be kept alive by artificial means if you're either permanently unconscious or incapacitated. And in that Supreme Court decision, which was called the Cruzon case, they did decide that every state in the union had to obey your wishes, but the state could require clear and convincing evidence of what your wishes were. And with that, there's nothing that's more clear and convincing than having your wishes in writing. So that was really the big impetus to have your wishes be put in writing concerning your medical care. And as a result, every state has their own law and generally their own form to carry out your wishes. But those are just suggested forms. You still have this constitutional right to control your own person. So that's why we can really modify whatever form we're going to prepare for you based on your wishes. So the first part of most of these advanced medical directives allow you to appoint a healthcare representative. And that is naming a person, if you can't make your own medical decisions, who do you want to name to make those medical decisions for you? And now state law does provide for that, just like they provide for what will happen to your property if you don't have a will. But most people want to be in control of those choices and name them specifically. So again, just like the financial power of attorney, it's important to have a trusted person make those decisions for you. And it may not be the same person who is in charge of making your financial decisions. It may be a totally different skill set. You might have one child who is in the medical field who would be much better making your medical decisions for you, and another child who's much better at finances. So those decisions of who you choose can be separate decisions. And the reason, again, for doing this is if you can't make your own medical decision, your medical professional doesn't know what you want or what decisions need to get made. And so someone would have to go to the probate court, and again, could be a very expensive process to go to the probate court and have someone named your conservator, which again, Attorney Dixon's going to go into this type of conservatorship as well. But that's why it's important for you to make a choice to tell the medical professionals who make your decisions for you. And this can be a really important job because we're not just talking about end-of-life decisions. If you think about all the medical decisions your doctor may ask you, there are all sorts of treatment decisions on every type of medical condition. Do you want to try drug therapy first? Do you want to try physical therapy first? Do you want to try surgery first? And they might explain the pros and cons, and ultimately you would make those decisions for yourself if you're capable of doing that. But God forbid you are incapacitated and can't make those decisions. You want someone you've thought about as a person who's capable of making those informed decisions. The next thing that we can put into that document is who would be your conservator should you need a conservator. And this, again, I'm going to leave to Attorney Dixon, but you can, if someone is going to go to probate court to try to overrule your decisions, you can sort of still control that court action by saying what your wishes would be if it ever got to that situation. The next part about that we usually talk about in your advanced medical directions is the part that's commonly called the living will part. And that is the part where you express your wishes concerning whether or not you want to be kept alive by life support at the very end of your life if you're either terminally ill or permanently unconscious. And you can really tailor that document to your wishes. And for instance, the statutory form, says if you're either permanently unconscious and terminally ill, you don't want CPR. Usually we end up as just one of a few examples, but you can add to those examples. And we usually spend some time explaining to clients, well, what the document is saying, and we try to make it as clear as possible, is that, if you're not terminally ill and you have a heart attack, you're going to get CPR. It's just we're talking about really end-of-life decisions where you're either permanently unconscious or terminally ill and at the end. And so beyond being very helpful to your medical, to making sure your wishes are carried out, and then being very helpful to your medical providers, putting your wishes like this in writing is really going to help your family come to grips with what your wishes are. And it's going to help avoid family disputes, because the larger the family there is, the better it is to have these things in writing, because there might be, it's more likely you might find somebody who just can't bear to part with you and wants to keep you alive for every last second, no matter what. And their view of end-of-life decisions may be very different from yours. So it's very important that you state what your wishes are and have the document prepared that you feel comfortable with. And again, I'll just mention another case that you may remember from, I think, the early 2000s in Florida. There was a tragic case of Terry Schiavo, who did not have her wishes in writing, and her husband had one idea and her parents had another idea of what her wishes were. And there was 14 different appeals of court cases and a 7-year delay, and lots of money spent. And it was just a tragic family situation that would have been avoided had her wishes been in writing. Some of the other things that an advanced medical directive can do is, if you're interested in being an organ donor, you can. There's a place in the Connecticut form, and I think most state forms, for becoming an organ donor. You can also talk about what you want for your disposition of remains, and who's going to be in charge of your remains, and whether you want a burial or cremation, which can really, again, minimize any family disputes when you've put your wishes in writing. And particularly, I think we find in second marriage situations where the kids of the first marriage might come into conflict with the spouse of the second marriage. We want to have those wishes really spelled out, which sort of brings me to something I didn't talk about for powers of attorney, but most attorneys will have a very important conversation with their clients as to who's going to keep these documents, who's going to get originals and copies, and so forth, and where some of your wishes should be. So it's particularly important with your medical healthcare document that it becomes part of your medical record, or at least your agent has an original, because they're going to need that while you're alive but disabled to give to your medical professionals. And likewise, these wishes should be in about your medical desires should be in your advanced medical directive and not in a will. And the same thing with your burial cremation decisions. Those could be in a will, but they should never be exclusively in the will. It's much better to have them in your advanced medical directive where people actually see it while you're alive. Frequently a will isn't obtained or reviewed until after the funeral, in which case if you wanted to be cremated and you were buried, that would be too late. So that's one reason we either do it in a separate document that will be distributed while you're alive or put into the advanced medical directive while you're alive. The other thing that we tend to do during in documents is some type of HIPAA privacy authorization form. Many of you, I'm sure, are aware of the HIPAA privacy laws, which basically means that your medical professionals are only authorized to talk to you unless they have your permission to talk to someone else. And this could be a broader group of people than just your agent that you're naming to make your medical decision for you. So you might say, well, I want my spouse to make my medical decisions if I can't, and then maybe my oldest child to make them if my spouse can't. But you might say, well, I want to give my doctor HIPAA authorization to talk to all my children so they all know what's going on, even if they're not the decision maker. So that's something that we commonly talk to clients about putting into their forms. And so this is really, designed to, again, make sure that your decisions regarding your medical care are carried out. And this is, again, really in the case that you are disabled, because as long as you are not disabled, or as long as you have capacity to make your own decisions, that's what controls. So even if you sign a advanced medical directive, as long as you are capable of making decisions to the doctor's satisfaction, you can countermand anything that you have in your living will. You can make your own decisions always. And you can also, like the power of attorney, amend or revoke the healthcare advanced medical directive that we're talking about. So you really have quite a lot of control, but it takes a lot of decision making and discussion with your advisor as to how you want your medical and power of attorney forms to read, because it might be very, very different from someone else that you meet at a cocktail party, or hear other ways that we hear the decisions sometimes get made outside of legal advice. The only other thing that I'll briefly mention before I'll see if there are any other questions, and then we'll hear about conservatorships, is that there is a new thing in medicine called both POLST and MOLST. In Connecticut, we have MOLST, which is Medical Orders for Life-Sustaining Treatment. And this has to do solely with end-of-life care, and it's regardless of your capacity, and it's something that you and the physician basically enter into together. So just in case you ever hear of that, that's not something that we've seen very much of in Connecticut, but it is another document that is out there. So that is what I wanted to tell you about. Attorney Dixon or Attorney Grenger, do you have any questions or things you want to add that I skipped over that would be important?
I don't have any questions. It was thorough as always. I did want to share that in my experience, many of my clients have come back to me later and just said, thank you for encouraging us to do these documents. My family was so glad when we told them that we had them all set up, and they thought it was a real kindness that we had taken the time to do it. So it is really important that people give them adequate thought as part of their estate plans.
Great.
So one of the things, Neal, that you were talking about is conversations. And you're talking about conversations with your legal advisors and your healthcare advisors, but you also need conversations with those that are going to be handling the affairs for you. And that's a very important part, because we don't really know exactly what someone's wishes are until we've had a conversation. I'll give you an example. I had two, a husband and wife that came in. The husband was dying of cancer. And they sat down. They were both very religious people. They were sweethearts, people I'd known for years. And I asked them, well, what do you want to do at the end of life? And the wife said, oh, I want to leave it in God's hands. And the husband said, I want to leave it in God's hands too. And I said, well, what do you mean by that? And he said, well, I don't want anything. I don't want anything hooked up. And she looked so shocked. She said, God made everything. Without that conversation, they would have had no clue what they were really talking about. So conversations are essential. Now, you go ahead, Neal.
I was going to say that's such a good point, and conversations, and especially with the agent, what your wishes really are, because it's one thing to have them in writing, but it's another thing to answer any questions the agent might have as to, well, what about this situation? What should I do?
Yeah, I suggest also that particularly with the healthcare directives, that they find a time every year to pull them out and review them and see whether they've changed their mind, and if possible, to have a conversation with the person who's going to be their representative. Another point on that I think needs to be brought out between the interplay of powers of attorney and the healthcare directives. Going back about probably 10, 15 years ago, healthcare was in a power of attorney. And no longer can a simple power of attorney be used for healthcare decisions. They seem to be able to be used for the financial aspects of it. But a lot of people still don't understand that. They think if I've given a power of attorney, I don't need to have a healthcare representative appointed. But the legislature in their wisdom found that there tended to be conflicts from time to time once they started doing the healthcare directives on a regular basis. People were naming somebody different, but they had the power still in the power of attorney. So they specifically said, no, you can no longer do that. So that's just another point. And I guess there was a couple of other quick things that I wanted to bring out as we transition into conservatorships. And I am transitioning into that right now.
All right. Can I name one more thing before that you reminded me of? Then that is in Connecticut, the law did change in 2016, I believe, for powers of attorney. The law did say older powers of attorney were still valid, but we have frequently found as attorneys that we can write what we all consider and agree amongst ourselves are brilliant documents, and we'll find out some financial institution will come up with some reason why they don't want to accept them. And one of the reasons may be that they are too old or so forth. So it's not a bad idea to revisit your whole estate plan every so often anyway, but maybe to re-sign that. But the new 2016 law does allow for the enforcement of powers of attorney. So one can go to probate court and basically make the power of attorney be respected by the financial institution, unless the financial institution can show some reason why it's not. So I had meant to mention that, and you reminded of me of that. So thank you. I'm gonna mute myself and let you transition into conservatorship.
I'm going to see if I can do this trick for just a second and put up my CV one more time. Let's see if it's here. There we are. Does that come up? Yeah, just so that people can be reminded who I am. And Neal and I go way back. I'm not going to talk about that in this formal thing, but he's, I think, one of the attorneys, as well as Ellin, that I go to when I need somebody to help advise me as well. So I think you have a very good group of people on here to do that. Now, one of the things, and I'm going to go back to my picture now, if I can figure out how to do that. Here we go. Is this coming out? No, I got to stop share. I'm sure they'll edit out this part. Okay, here I am. So one of the things that I think the structure of this whole series of programs is that the one that's number one was talking about what happens after you've passed away. This program talks about what happens if you're still alive and have some issues toward perhaps not even toward the end of your life, but through the process of your life. And in many ways, I think this is more important because the state of Connecticut has made some very good general rules. If you die without having a will, you're going to get taken care of. Might not be exactly what you want, but if you're alive and you have to have some of these problems, then the things that Neal talked about are essential in order to be able to help your loved ones manage your affairs without the need to go to probate court. Now, sometimes you have to go to probate court, and that's what I'm talking about. The reason I say have to go to probate court and put it in that context is because there is a real downside to a conservatorship if it's not necessary. If you can take care of your affairs through a power of attorney or through healthcare directives or other means which will be talked about in the next section, which include trusts and how you title your assets, which Neal hit on it a few moments ago, you can avoid the need for a conservatorship. Conservatorships require going to court. You lose very often a right of control over your own affairs. There was one old court case that likened someone on prisoner's row to having more rights than someone who's been conserved. Now, I think that was probably a little excessive, but the point was there that you do have to go to probate court if you have been conserved, if you don't like what's going on, or the conservator has to go for certain things that I'll talk about. Second thing is you lose a certain degree of privacy because interested people can become involved in the probate process. And you might, relatives, for example, that are trying to find things that you don't want them to know. And I've had cases of that where we have pulled a voluntary conservatorship because the woman who wanted somebody to take over decided that the way her other members of her family were acting, it was improper, and she didn't want them to have further knowledge. We ended up using a power of attorney in that case, and the matter was resolved quite nicely. You also have additional costs. There's court costs when you have to go there. There's costs of an attorney because to go for a conservatorship, you're going to have an attorney appointed for you, even if you don't have your own, by the court, because the court wants to make sure that your rights are being protected. But when all else fails, it's a very valuable and necessary alternative. There are many people who have no close relatives out there that need assistance, and to have the court oversight so we know that people are not going to abuse their financial or personal rights. The court takes that very seriously and does a really good job in most cases. So the basic information that I think I want to jump into there is that prior to 2007, Neal talked about changes in the Power of Attorney Act. Well, from time to time, us lawyers get together through the Bar Association and say, we need to make some fixes. And back in 2007, prior to that, the process of a conservatorship was rather informal. And there were some significant due process concerns where conservatorships were being sanctioned by the court when they probably shouldn't have been, and the court really didn't have the process down to where you could protect your rights. So in 2007, there was a major redo, and there's been some minor ones since then, but it makes it much more of a formal process where it has to be on the record. There has to be certain jurisdictional requirements that are met that I'll talk about. But there are a number of different types of conservatorships. So I want to talk about that first before we go into some of the procedural matters. A conservatorship can be voluntary or involuntary, which means somebody could decide they are just getting tired of managing their affairs. There's nobody else around that wants to take over the affairs. And so they're going to reach out to the court, and the court's going to find somebody that will do that. There's a number of attorneys and other individuals who make themselves available to the court to help out in these cases. They understand that they're going to be scrutinized by the court, and so there is some standards there. But so that's voluntary. And under a voluntary, the person pretty much just decides, I want to do it. They still have to go through a formal process. But the one that we think about most when we talk about conservatorships is the involuntary one. And involuntary representation, I'm going to read parts of the law because I think it's the best way to do it, is after a finding by the probate court that the respondent is incapable of managing his or her affairs and incapable of caring for him or herself. There has to be a finding that the person is incapable if it's an involuntary one. And that requires certain things as well as a hearing. So in a voluntary representation, there is no need to require a finding of incompetency or incapable. They both do, as I said, require a hearing, and that's appropriate, but the formality of the involuntary is much more specific. Now, having said that there's voluntary and involuntary, there also are two other types. You can have a conservator of the person, and you can have a conservator of the estate. And you can have a voluntary and involuntary with each one of those. There's another additional type of conservatorship, which I'm not going to go into the details of, and that's an emergency one, an ex parte one, because there are certain conditions when the emergency requires action by the court with a temporary abandonment of some of the due process considerations for the well-being of the person who is to be conserved, which in Connecticut, after the change of law, is called the respondent. Sometimes words matter, and respondent seem to be a more neutral word than some of the old terms that we use. Excuse me. So, conservator of the person. That means a person appointed by the court to supervise the personal affairs of a person found to be incapable of caring for himself or herself, or a person who voluntarily asked for the probate court for the appointment of a conservator. And then also said that there's some temporary ones that can fit there. Conservator of the estate means a person appointed by the probate court to supervise the financial affairs of the person found to be incapable of managing his or her own affairs, or again, the voluntary situation. So how do you go about this? Well, and I guess another question is who can do it? Pretty much any interested person can file for a conservatorship. The petitioner, they have to pay the cost of the court to file, so it's not something that somebody's going to do. And there are certain further requirements that I'll come to in a moment. But you can't just automatically take somebody and go to a court. There has to be certain requirements, such as residence in Connecticut. So if Aunt Annie is visiting from Florida and she gets a little bit out of sorts after the first week she's here, you're going to have to go to Florida if you think she needs to be conserved. You can't do it in Connecticut. There's also a question of what probate court in Connecticut. So you have 6 months or more in Connecticut, and then the jurisdiction can kick in. But the local court has to decide who's going to handle it. It can be a little confusing at times because it's not just where your permanent residence is. If you're in the hospital, that jurisdiction can take jurisdiction. If you are temporarily living in another part of Connecticut, that can also be considered jurisdiction. So occasionally you get into questions of where you should go. And frankly, there can sometimes be jurisdictional shopping that goes on between different probate courts, because despite the attempt to unify the law as much as possible, different courts do handle things in different ways. So any interested person can petition, and that includes a municipal or state official, a corporation, limited liability companies can be, they can be the person who also can be the conservator or that. So it's a very broad situation, except certain types of situations can't, and they're more specifically defined in the statute, and I'm not going to get into those details. But generally speaking, though, the petitioner is going to be somebody who has an interest in the person. The reason that municipalities can do it is because sometimes their social workers realize there's no one else around that can do it, so they can take over and do it. Hospitals can find people in their care that need some attention and don't have anyone else to take care of it, haven't done their healthcare directors and so forth. They can then petition the court as well, and it goes forward. Now, if you fraudulently or with malicious application or intent or false testimony, process this. If you file one and it's a malicious application, or if you're there and you make false testimony, you can be subject to criminal charges, and it's a Class D felony. So one doesn't do this lightly. You have to make sure that you really do. You're not just doing it to Aunt Annie from Florida, who happens to stay 6 months because you want to try to get control of her money. I say some of these things almost tongue in cheek, but unfortunately this does sometimes happen, which is why the court back in 2007 of the legislature made some changes, because they wanted to eliminate the types of conservatorships that were really parts of family disputes rather than because of the need for a conservator in that case. Jurisdictional requirements. I said that you have to be in Connecticut for 6 months. You also have to have personal service. That can become an issue at times because there can be some defects in the service where someone didn't personally get it. And then everything stops if the court follows the law. There also, if it's an involuntary, there has to be a medical report indicating that there are certain findings that are very specific by a doctor with regard to that person. And that has to be within 45 days of the date that you are using the report. It can't be older. You can file and it can lag around, but if you go past that 45 days, then there's a jurisdictional problem where the court doesn't have the right to do it. Now, having said that, there can be workarounds to that. If a person refuses to go to the doctor and you can demonstrate to the court, that jurisdictional defect can be overcome. But the courts are very, very careful to make sure that they aren't making a legal decision without having the medical information to support it. There's an absolute right to a hearing. Again, there's temporary ones where they can be done ex parte. And for those that don't know what that means, if somebody's listening to it, that means that you can do it essentially by affidavits and by evidence that's only certified rather than the actual hearing. But those can only be done by a showing that there's a grave emergency, and they can only last for 30 days without having the opportunity to come back to court. You also have the right, the hearing also has to be on the record. In the past, it wasn't always on the record, and it was hard for appeals to happen. And also now, if there is an appeal, it is based on the record. It used to be you'd have to go to Superior Court to start a whole new trial before the law. And all that got very costly and prohibitive for many families who felt that something had gone wrong. So again, the major changes tried to prevent all of that from happening, and it's working a whole lot better than it used to, frankly. You also have the right to an attorney, and if you don't have your own attorney, you can't pay for it, the court will appoint one. There's a very good list of good attorneys out there that do give some of their time. They do charge for their time. If you are impoverished and you file with the court, then the court does have a fund to help pay for that too. So they want to make sure somebody does have an attorney in that process. So as this is a very important diminution of your rights, I guess is the way of putting it, the trial has to show, and the evidence has to show by clear and convincing evidence, that the person is incapable and cannot adequately be cared for without the appointment of a conservator. Those are specific findings that the court has to make. In the process, they have to take into consideration a lot of other specific factors that were also made part of the law, and they have to use the least restrictive method to try to conserve this person and have so that their rights are limited only to the least possible way. You also have to use the formal rules of probate procedure, and also rules of evidence must be followed. In the past, it was kind of an informal hearing where the family would sit around, talk to the judge, and convince the judge that there was a problem here. And most of the judges were, very mindful of the process, and were trying to do a very good job of understanding the family dynamics. But there were times when they listened perhaps too much to one particular person and not another, and the opportunities to put in evidence weren't there. So mistakes were made in the past. There are many fewer mistakes made today, although it's not without some arguments from time to time. So what does incapable mean? The statute says incapable of caring for oneself means that a person has a mental, emotional, or physical condition that results in such a person being unable to receive and evaluate information or make or communicate decisions to such an extent that the person is unable, even with the appropriate assistance, to meet essential requirements for their personal needs. It's a mouthful, but that's really what we're talking about is Aunt Annie can no longer take care of herself. So you have to show that to the court if you are going to be looking for a conservator of the person. Likewise, if you're looking for a conservator of the estate, the person is incapable of managing his or her affairs, means the person has a mental, emotional, or physical condition that results in such person being unable to receive and evaluate information or make or communicate decisions to such an extent that the person is unable, even with appropriate assistance, to perform the functions inherent in managing his or her affairs, and the person has property that will be wasted or dissipated unless adequate property management is provided, or the funds are needed for support, care, welfare of the person or those entitled to be supported by that person, and is unable to take the necessary steps to obtain or provide those funds. So there's some very specific language in the statutes, and I read that particularly because what you as an individual thinking about one of your loved ones, relatives, who is doing some things that you think are perhaps unwise, that you're questioning their judgment, that may not rise to the standard that they're incapable of it. If they're living in a house of a hoarder, for example, that doesn't mean they're incapable. It may be something that we frown on, that we don't particularly like, but that in itself is not going to make them incapable. And somebody who decides to go up to the casino and spend a lot of their money, that doesn't mean that they're incapable of managing their own affairs. That happens all the time. And back to another point, I'm going to shift gears slightly, but with a power of attorney, one of the things that is the tipping point between a power of attorney and going for a conservatorship very often is the question of duty. A person with a power of attorney, if someone asked, and there was a court case on this one that I was involved in, but someone asked their daughter to go get a bunch of money out of the bank so they could go up to the casino and use the power of attorney to do that and gamble. Another daughter brought a court action saying, well, she had a duty not to let my dad go to the casino. Well, it turns out, no, there's no duty there. But on the other hand, if a person was conserved and they wanted to go spend a significant amount of money up at the casino, and the conservator allowed that, there's a pretty good chance that the sister would have had a cause of action against her other sister for having not taken the care. So it's a question of what the duty is between the two, and a conservator, because they have to do what is best for the client, not necessarily what the client wants, what the conserved person or the respondent wants. There is a difference between the two. It's not a black and white situation. It slides through. And we can probably talk a little bit more of that at the end. I'm sure Neal would like to pop in on that a little bit. So what we have then is very specific statutory requirements, and the court then has to make findings by clear and convincing evidence that those things were met. And then once they have made those findings and made that determination after a hearing and after good evidence has come in, then they have to decide what they're going to do. They have to make orders. Again, in the past, the orders tended to be just a general, okay, we're going to approach that. I'm going to have to plug myself in. I'm sorry for a second while I do that. I'm getting a notice that I'm short on power. Okay. So excuse me for that. So the courts, I'm trying to pick up where I was. So the court has to make those decisions that are very specific in terms of both the evidence, as I said, but also now what the conservator is going to be able to do, and they have to do it by reasonable alternatives and the least restrictive means. This is where those other items come into play, because if a person has already made determinations with regard to who they want for conservator, has power of attorney, or has a revocable trust that provides for incapacity, the court may at that point say, okay, there is an incapacity here. The person is incapable, but they've already taken care of their affairs. So, gee, maybe we don't have to do anything. More likely than not, there will be some kind of a sliding scale between the two, and the person with the power of attorney holding that power may still be able to act on behalf of the conserved person at that point, or not. It's going to be up to the court to decide it. They have to take into consideration the respondent's ability. So not everybody who is found incapable comes from the same cut. Some people are only incapable of not going to the casino, where they can definitely dabble in the stock market and do pretty well there. So there may be some, I'm making that a little facetious, but that's the type of thing that does need to be considered. To what degree the incapacity is affecting the life. And they also have to consider, the conservator has to consider the preferences and the choices both prior that were made, but also in the ongoing process that the conserved person has. So it's not just like being thrown on death row like that court case said many, many years ago. They also have to consider their cultural background. Those are some specific things in the statute, because what one particular cultural group thinks is appropriate, another cultural group might not think is appropriate. And that has to be taken into consideration. They also have to take into consideration the continuity of the environment and the respondent's life. So if they've been living in the same house forever and ever, there's going to be a stronger desire to keep them there and provide facilities for them to stay there. And as I said, the previously made alternatives, the powers of attorney, the trusts, and as you'll see in the next section of this section 3, sometimes the way their accounts are titled can provide a means for taking care without having to actually go so far as to have the conservator appointed. And then supportive services and technologies. People who can get around in a wheelchair because maybe they didn't have a wheelchair, and maybe that's the way to help make it a little bit easier for them to live. So all those things have to be considered, because what the law that was changed in 2007 envisioned is tailor-made conservatorships rather than one size fits all. So the court makes specific findings, the decree must be specific, and the conservator then gets appointed if that seems to be the appropriate thing. And again, even with the finding of incapable, doesn't necessarily mean that there's going to be a conservator appointed. Usually there is, but it doesn't necessarily mean that. So post decree, they made the decision, and the conservator of the person or the conservator of the estate has been appointed, or there's been a voluntary appointment without the finding of the incapacity. And Neal talked about a little bit with regard to powers of attorney that sometimes third parties give us a hard time about doing certain things. Occasionally, you'll find that even with a general court authority, someone will say, well, that's not enough for me. And the conservator might have to go back to court to get a specific authorization or approval. The healthcare representative, they stay involved unless the court specifically says they don't. So, and that's again, default within the law is if you've chosen somebody to be your healthcare representative, they continue, and the conservator has to abide by their wishes unless there's good cause, in which case they need to normally go to probate court to have the judge make the determination. Any move to a new place of residence has to be specifically authorized by the probate court once you've been conserved. There's a requirement if you own real estate to be put on the land, a notice on the land records. And then you have to do an inventory. You have to report to the court within the first year, and then every 3 years after, and you must keep good records. So those are very important aspects of the process. To be a conservator is accepting a responsibility and a duty. And that kind of goes back to powers of attorney too, which is also a responsibility once you've accepted them. You have to have people in your life that can help you. If you have people that you can trust with powers of attorney, that often is a much better way. But if not, you have the court there as a backup to make sure that you're as you age, as you go through, or as you have disabilities, that you can maintain your life. There's a separate thing if you are intellectual disabilities. There's a guardianship process. We're not talking about that. Take a deep breath. Anybody have any comments? There's a lot more we could talk about, but I know we're running toward the end of the time.
No, I think you did an excellent job of summarizing conservatorships and you know why it's everything that's involved and why it's good to get ahead of all of these situations with some planning.
Someone at a conference that I was giving said, doing good pre-death planning is a big gift to your loved ones, because you've taken care of it, they then can follow it. So think of it in that terms. You're giving a gift to your family, to those that you love, by taking care of business.
So I think, Ben, we can leave it there. And I don't know if Attorney Grenger wants to say anything in parting. I can put up our contact information in the meantime, if I remember how to do that.
That would be great, Neal. I just want to thank both of you for your very thoughtful and comprehensive presentations. I would really like to thank the offices at the Mystic Seaport for allowing the Estate and Tax Planning Council to benefit from their production capabilities and their Zoom account and technical expertise as well. So thank you to everybody who spent some time watching this. If you've got any questions, our contact information should be up on the screen in just a moment, and please feel free to follow up with any of us.